Hello, everyone. Welcome to the last session for today. We like to think of it as the best session of the day. I am Kirsten Stewart, and I'm one of the members in the Employee Benefits Group. And I'm here with George Tsai, and we're going to talk about employee benefits and COVID-19. We'd like to say there hasn't been very much going on during the pandemic, but that's not true. We have a lot to cover today. So we'll get right into it. To start off with, we want to talk about the rules that are applicable to all ERISA the kind of ground basis there. And we want to talk about the disaster relief. So during this COVID-19 outbreak period, there have been a number of deadlines extended when it comes to ERISA plans. So HIPAA special enrollment right notices that participants would have to give in the case of a birth or marriage, the deadlines to pay for COBRA premiums, deadlines to individuals of certain qualifying events under COBRA. Even the deadline to elect COBRA continuation coverage has been extended. Also, the deadlines to file benefit claims to appeal adverse benefit determinations under plans claims procedures have been extended. And this also applies to retirement plan claims, health flexible spending accounts, not just group health coverage. And also the 4-month deadline for submitting claims to independent reviewers under the Affordable Care Act has been extended. There's also been extensions for plan administrators. Group health plans have suspended deadlines for COBRA election notices in certain circumstances. And George is going to talk about later the relief that's addressed for retirement plans under this relief system. So what does this mean? So for any of those deadlines that occurred on or after March 1st, 2020, your plan has to disregard these periods from the earlier of the anniversary of the original or the end of the outbreak period. And so this will last generally until 60 days after the announced end of the COVID-19 national emergency or another date announced by the federal government. So since the national emergency is still ongoing, the deadline for all those events that have occurred as of this date up from June 3rd, 2020, is the year before, that deadline has expired. So you can't have someone who comes to you and says, I had a baby last April 2020, and I want to add my child to the plan now. They can't do that at this point. However, anything that happens from June 4th, 2020 through August 3rd, 2020, anything that occurred then, that deadline ends no earlier than the anniversary of that date. And anything that occurs beginning August 4th, 2020 until whenever, those deadlines have been suspended until the earlier of the anniversary of that event or 60 days after the end of the national emergency. Also, in addition to this, if a plan fiduciary knows or know that the end of any of these relief periods will expose a participant or beneficiary to a risk of losing these protections, like under HIPAA special enrollment, COBRA election right, then the DOL wants fiduciaries to consider affirmatively sending a notice regarding the end of the relief period. And also disclosures and notices that have been issued during the pandemic may need to be reissued or amended. So if you have someone who hasn't elected COBRA at all for almost a year now, right? And are coming close to the end of that deadline, the DOL thinks that you should go to them and tell them what's happening and that they're going to run out of this right pretty soon. Also, during this disaster relief period, fiduciaries have a little bit of an extension or sort of a grace period with respect to ERISA disclosures and claims processing requirements if they're acting in good faith and with reasonable diligence under the circumstances. So I think that would have been definitely something that plan fiduciaries could have used at the beginning of the pandemic. I think now as things are hopefully settling out, that suspension of deadlines, I'm not sure what a good reason or diligence would be at this point, and having the ability to extend it for that as well. So now we're going to talk about cafeteria plans, and there have been a lot of things that have happened with respect to those plans. This has been under the Consolidated Act of 2021 and a notice that came out earlier this year, which gives flexibility for plan years ending in 2020 and 2021. And as anyone who has a cafeteria plan knows, generally elections for those plans and the benefits offered under those plans have to be irrevocable and determined before the beginning of that applicable plan year. However, this flexibility can be used by plan sponsors if they want to. These are all optional as opposed to the disaster relief that we just talked about, which is mandatory. But these are things that you can consider as you're going through. Carryovers are allowed for health and dependent care flexible spending accounts. The entire amount, even if the carryover would be over the general $550 limit for health flexible spending accounts. Grace periods can be extended from the 2.5 months to 12 months after the end of the plan years. There's a temporary rule that allows individuals to claim post-termination reimbursements from health flexible spending accounts without having to elect COBRA. And there's also temporary claims periods and carryovers for dependent care flexible spending accounts available if a dependent ages out. So if you have a participant with a dependent who turned 14 during these, or 13 to 14 during this period of time, you can allow some flexibility using up those reimbursements. And there's also prospective mid-year election changes without a change in status permitted for health flexible spending accounts, dependent care flexible spending accounts, and health plans. We've had a lot of employers use and basic with certain limitations if they wanted to, but basically something that you're interested in giving people the ability to change their elections during this pandemic, especially with dependent care, where a lot of people weren't able to use their flexible spending accounts because of closures of daycares and things like that. So if you decide to use these, all options selected under this guidance have to be put into a plan amendment, and that plan amendment can be retroactive. But you also have to make sure to inform all employees eligible of the changes in the plan. So generally you want to send out a summary of material modification or some other notice that gives employees the opportunity to understand these rules and to then use their accounts if necessary. So let's see. Also increased the maximum allowed under the dependent care flexible spending account from $5,000 to $10,500 just for the 2021 taxable year. This was a pretty big surprise when it came out earlier this year. Keep in mind it is a temporary change. And then also by increasing that limit, if you decide to do that for your plan, keep in mind that there may be some impact to your non-discrimination testing, depending upon who takes advantage of that additional amount that you can contribute to the dependent care flexible spending account. So another thing is that the amendment is required to be put in the plan no later than the last day of the 2021 plan year, essentially. So that's something to keep in mind. Again, this is, if you decide to do this, it's something that you want to let participants know about as soon as possible so they can take advantage of it. You would also want to have the optional provision of allowing people to change their dependent care flexible spending account elections mid-year, we talked about before. And you also may want to consider a carryover or a grace period with respect to, some years here, so that there's a possibility of using this amount if they're not able to use it during the 2021 taxable year. Also remember, if you have a non-calendar year dependent care account, $10,500 can get a little tricky because it's based on the participant's taxable year, which is always the calendar year. Also, over the last 2 years, there's been guidance allowing new eligible expenses for medical care under health flexible spending accounts. These are all can be effective retroactively to January 1st, 2020. Keep in mind that in a lot of cases, the claims period for a health flexible spending account for the 2020 plan year would have normally ended sometime in 2021, but we're still in the extended relief period, the disaster relief period. So there's still an additional period of time for folks to be able to get their claims in. So even though this is effective, it can be effective retroactively. Keep in mind that participants can take advantages of this if they want to. And those new expenses are over-the-counter drugs without a prescription. You may remember that we've gone back and forth about whether OTC drugs have to have a prescription or not in order to be eligible for medical expenses over the years. Menstrual care products have also been added. And then personal protective equipment, masks, hand sanitizer, and sanitizing wipes also can be eligible expenses under health flexible spending account. So participants who may are able to substantiate these amounts over the last couple of years, and if you add this to your cafeteria plan, this is something that they can take advantage of and use their account balances for. Generally, this is an optional provision. However, if your cafeteria plan just basically refers to Code Section 213D, these will be automatically applied and would automatically go into effect. Now, if that's not enough, we have group health plan changes. This has gotten a lot of news and a lot of things for employers to work on, and this is all through the American Rescue Plan. And so this is the COBRA Premium Assistance. This applies to ERISA group health plans, including those that are not subject to federal COBRA, also state and local governmental plans. It does not apply to churches, which have to generally apply or are not subject to COBRA. But essentially, for COBRA premiums beginning in April through September of this year, an assistance-eligible individual has to be treated as having paid the full amount of any premium. And this premium assistance applies to medical, dental, vision, and other group health plans, but it doesn't have to apply to health flexible spending accounts. Now, this means that 100% of the COBRA premium subsidy, which also includes the 2% administrative fee that plans can charge for COBRA, it has to be treated as fully paid. It doesn't include any subsidy an employer would have provided to other individuals under the circumstance. So, for example, if you have a severance plan for someone who terminated, right, and they are given a 40% premium subsidy, you can't treat that as part of the premium assistance for the tax credits, which we'll talk about in a few minutes. And also, if the coverage, so it goes individual by individual, and we'll talk about what an assistance eligible individual is in a minute. But if you have a group who have elected COBRA together, one or more are not eligible for this premium, you only have to look at the incremental cost of providing that benefit for the non-assistance eligible individual to back out of the COBRA premium assistance. So it doesn't cost anything more to have someone take COBRA, even if they're not an assistance eligible individual. You don't have to somehow try to figure out the value of that coverage for purposes of calculating what the assistance is that's actually available to individuals. So an assistance-eligible individual, there's been a lot of questions about this. That's any individual who's a qualified beneficiary at some point from April through September of this year, who's eligible for COBRA by reason of a termination of employment or reduction of hours other than a voluntary termination and elects COBRA. So based on some information, additional guidance that we've had on this, I put together sort of a chart of who could be assistance eligible individuals and who couldn't be. So employees who have had their hours reduced, even if it's voluntary or involuntary, so leaves of absences, furloughs, et cetera, those could potentially be assistance eligible individuals. Employees whose employment is involuntarily terminated, they are also AEIs. And spouses and dependents who lose coverage due to an employee's reduction in hour or voluntary termination are also eligible. Examples of ineligible individuals are those whose hours are reduced but don't lose coverage. So for example, if you have employees that go out on a leave of absence but their coverage doesn't get terminated during that period of time, they wouldn't be eligible. They're not even eligible for COBRA. Employees who voluntarily terminate or whose employment is terminated due to gross misconduct are not eligible. Spouses and dependents who lose coverage due to divorce, death, or aging out. Domestic partners and their children are also not eligible for the premium assistance, even if you offer them COBRA-like benefits. And employees whose coverage is terminated because the employer is terminating the entire plan, they also wouldn't be eligible for premium assistance. They're not even eligible for COBRA. So what is an involuntary termination of employment? The guidance says it's a severance from employment due to the independent exercise of the unilateral authority of the employer to terminate employment, other than due to the employee's implicit or explicit request, where the employee was willing and able to continue performing the services. So this can include a termination for good reason. If there's a material negative change that's being made to the employee's employment and the employee decides to quit. So there's been a lot of questions about how this will work. And so I put together another chart of COBRA premium, who would be considered involuntary or involuntary. So examples, if you have an employee who is terminating employment when they're absent for work due to illness or disability, where there was a reasonable expectation that the employee would return after that illness or disability. If the employer decides to terminate that employment, that's an involuntary termination. Termination of employment due to cause, even if you are terminating someone for poor work performance, for example, they would be eligible for COBRA in most circumstances, and they would be eligible for the premium assistance. Resignation as a result of material change in the location of employment would be an involuntary termination. Participation in a window program, even those who would have had impending terminations anyway, that's involuntary. Employee-initiated termination in response to an involuntary material reduction in hours that didn't result in loss of coverage. Not involuntary terminations in general. Retirement or death will not qualify an employee or their spouse or dependent for premium assistance. Termination of employment due to general concerns about workplace safety is also not considered an involuntary termination. Departures due to personal circumstances of the employee unrelated to the employer, like a health condition or an inability to find daycare, even though that may not be considered having anything to do with the employer taking inaction, that's still considered voluntary for these purposes. And then an employee-initiated termination of employment because a child is unable to attend school or have childcare or where their child care facility is closed. Also wouldn't be considered involuntary termination eligible for the premium assistance. Now, on top of this, keep in mind that even if you're an assistance eligible individual, you're not eligible for the premium assistance in 3 different circumstances. For example, one of them is, so the premium assistance generally is going to cut off anyway in September. However, if the individual is eligible for coverage under any group health plan or eligible for Medicare, that individual is not eligible for COBRA premium assistance. Also, if the maximum continuation period for the employee, so for example, we're in the last 16th, 17th, 18th month of COBRA, at the end of the 18 months, the premium assistance will also cut off. Anything else that would cut off COBRA, this will not extend anything beyond what's allowed under the federal law. Keep in mind that even if the premium assistance gets cut off, some of these individuals may still have a continuing COBRA right, even if the premium assistance won't apply. So if they're eligible for coverage under another group health plan, they're not eligible for the premium assistance, but they still have a COBRA right because they haven't actually enrolled in that coverage. So it's something to keep in mind. It's a different definition, looking only at eligibility. The DOL has provided a form on which individuals can use to establish their eligibility, and a form on which they can notify the employer that they're no longer eligible. Now, why is that important? Because as the plan sponsor, you're not probably going to know, even if you have someone who's involuntarily terminated, whether they're really eligible for the premium assistance. So because you're not going to know whether they have a spouse that's eligible, has group health plan for which the individual can join, you're not going to necessarily know if they're eligible for Medicare in certain circumstances. And so you need to have some way of showing that these people are actually eligible for the premium assistance. It puts a lot of burden on the employer, but it's important because the IRS is going to require documented proof and substantiation of the eligibility for the tax credit. You don't have to use the actual form for this, but you need to have some way of documenting that you've actually made sure that the person is eligible and give them the ability to actually notify you if they're no longer eligible. The law puts a requirement on the assistance eligible individual to notify you that they're no longer eligible for a subsidy. They say it's a requirement to be done in a time manner. I haven't seen anything that describes what that deadline is. And if they don't notify you and they still try to rely on the premium subsidy, the DOL can impose a penalty of up to $250 for each failure. So there's a penalty on the individual to notify you. Also, just to go back to that, there's also potential penalties for the employer. I mean, some employers might just want to say, oh, I'm just going to give 100% subsidy to everyone, and I'm not going to go in and ask for people to substantiate it. Well, then in that case, it's potentially you're underpaying the taxes that you would owe for employment taxes if you don't have that documentation. So there is also a need for the employer to make sure that they have good documentation and that they're trying to make sure that people are actually eligible for the assistance. There's also a new COBRA election rights. The plans generally have to, and this is only for plans subject to federal COBRA, you have to offer an extended election for folks who didn't have an election of COBRA in effect on April 1st, 2021. So those are folks who would have been in an AEI if the individual had a COBRA continuation coverage election in effect on April 1st, or someone who previously elected COBRA and discontinued that coverage before April 1st, 2021. Now, those notices were required to be sent out by May 31st, 2021. And these individuals are allowed to elect COBRA continuation coverage effective April 1st. And they have until the 60th day after receiving the notice of this new right to take that election right. And they have the right to begin coverage April 1st under this new election right, or begin it prospectively from the date of the election. This is in addition to the retroactive COBRA premium right that they would have had under the disaster relief that we talked about at the top of our presentation. And for this case, if a qualified beneficiary received a COBRA notice before April 1st and received the notices of the extended election period, then that qualified beneficiary can elect COBRA continuation coverage with premium assistance for the coverage, and they also have the right to elect or decline coverage retroactive to the loss of coverage if eligible. So once they get that notice, they have to decide whether or not to go back retroactively. It will hopefully cut some of that additional issues with the disaster relief in these instances. So once the qualified beneficiary in this case elects COBRA with the premium assistance, if they don't elect the retroactive coverage, then their right is waived. As I said, the extension of deadlines available under the disaster relief don't apply to this extended period notice or to the extended election period. And again, the extensions of the deadlines under disaster relief remain available for premium payments for retroactive periods of coverage. So even though they elect it retroactively, they may still have an extended relief period where they don't have to make their payments straight away. So you need to make sure that you're looking at the disaster relief in connection with these election rights. So there's a bunch of notice requirements. There's a general notice to all qualified beneficiaries who have a qualifying event that would meet these requirements from April 1st through September 30th. There's also a notice of the extended COBRA election period for those who have that right. And you're also required to give a notice of expiration of the premium assistance. And this must be provided 15 to 45 days before the premium assistance expires. And this is not required when the subsidy ends because they become eligible for coverage under another group health plan on Medicare. But if it's going to end for other reasons, for example, we're getting close to the end of September, right? That there needs to be an expiration notice sent out to participants. So you've treated everyone as having paid their COBRA premium assistance. What happens next? So in that case, the employer, or who's called the premium payee, that individual has a right to receive a tax credit for the amount. And it gets allowed as a credit against Medicare payroll tax for each calendar quarter. So for instance, if you are a governmental employer, you don't pay into Social Security, you still pay into Medicare. That's where your tax credit will come from that Medicare piece. It's equal to the premium that's not paid by the assistance eligible individual for the coverage. If it exceeds the amount of taxes, then the excess can be treated as an overpayment of taxes that will be refunded. There's ways of getting an advance of the credit as well. And the credit is included in the gross income of I'm using employer here. If your plan is fully insured, the premium payer is the one that handles the tax credit. But in this case, if you have a self-insured plan and you receive the tax credit, it's included in the gross income of the employer. Other obligations, if you have someone who is eligible and pays for the premiums during the period of April through September, you have to reimburse that individual for the amount paid. That's an affirmative obligation that you have. You can't apply it to other months. For example, you can't hold on to it and then use it for future months after September. You have to actually pay them back. Other recent developments, I just mentioned this very briefly. There's a lot of things going on, and these all came up in laws that were passed earlier this year, actually. There's new surprise medical billing coverage and disclosure requirements. Those are coming for 2022. These are all building off of the Affordable Care Act, and they're pretty significant notices. They're intended to protect consumers from surprise medical bills, and there's new rules on continuing care. There's also new transparency rules. There's a requirement for advanced explanation of benefits. A price comparison tool is required. You're required to have specific provider directories that are updated. And there are also balanced billing protection disclosures. So these are all very important. They are, just building off of the Affordable Care Act. Something that's in effect right now is mental health parity documentation requirements, and those are for non-quantitative treatment limitations. Those are in effect now. So in essence, if the government comes in and asks for proof that your plans provide parity in benefits for mental health or substance use disorders, you need to be able to show that you've done a comparison and that you can show that the limitations aren't skewed to improperly impacting the mental health or substance abuse benefits. So it's a pretty important thing, especially if you are asked by the government to provide you with this information. You really need to be working now to make sure that your third-party administrator or your insurer is going to be able to provide that information and respond accordingly to those rules. I know that was a lot. I'm going to pass this over to George for some retirement plan rules. Take it away.
Great. Thanks, Kirsten. That was very helpful. My name is George Tsai. I'm a member at Sherman and Howard in the same group as Kirsten, the employee benefits group. There were certainly a number of developments also on the retirement plan side of the world, especially last year. Related to COVID. We will cover, kind of briefly walk through what those developments were and what you need to take away as plan sponsors as far as what you need to do for your plans. I'll also walk through in some detail the good faith relief, and finally I will address some recent guidance that was fairly recently released by the DOL with respect to cybersecurity, not directly related to COVID per se, but certainly has been in the news a lot lately with all the cyber attacks, and really represented, this guidance that the DOL released really represented the first round of cybersecurity guidance for plan fiduciaries, which is especially relevant nowadays as obviously we're doing a great number of things online and remotely. So without further ado, I'll page to the next slide. So these first few slides are going to basically recap some of the COVID relief that was initially offered under the CARES Act. I'm sure everybody here has heard of the CARES Act. And after it was initially promulgated by the CARES Act, it was subsequently kind of refined by a number of IRS notices. And so these slides address kind of the current state of these relief provisions. So I'll start with so-called coronavirus-related distributions, or commonly referred to as CRDs. just to refresh everyone's memory, these were distributions from qualified retirement plans or IRAs that were made basically last year, so between January 1st, 2020 and December 31st, 2020, from an eligible retirement plan. They were limited to $100,000 across, any plan that you participate in. So if a participant participated in a qualified retirement plan and an IRA, the limit was $100,000 across those two plans. By way of example, you had to be a so-called qualifying individual or qualified individual. So somebody who is impacted in some way or whose family member was impacted in some way by the coronavirus pandemic. I'll go over kind of how that definition evolved. And finally, the kind of big takeaway or why this provided relief was kind of twofold. In the case of qualified retirement plans, or many types of qualified defined contribution retirement plans, that basically created a new distribution right. And in addition, the relief distributions that were made were not subject to the 10% early withdrawal penalty. So on this first slide, that was just kind of a recap of what CRDs are. As I mentioned, they were initially authorized by the CARES Act. Subsequently, the IRS released a notice that basically expanded the list of events that could qualify somebody as a qualifying individual. The real difference there between the initial definition and the revised definition was it was expanded to include, the initial guidance only really included the participant and his or her spouse, but that was substantially increased to include a member of the participant's household. Also, if anyone in that household or the participant suffered a financial impact by reason of the coronavirus pandemic, they could qualify as a qualified individual for purposes of taking out a CRD. So as far as what plan sponsors needed to do, a lot of plan sponsors ended up working with their TPAs, who were really the ones who kind of drafted the forms that people had to fill out in order to take out CRDs. Essentially, the legislation required a self-certification on the part of the participant for any sort of CRDs, also for any sort of loan relief, which was also predicated on somebody qualifying as a so-called qualified individual. The real takeaway here from the employer and plan sponsor side is that, as a plan sponsor, you're allowed to rely on a certification unless you have actual knowledge to the contrary. And that actual knowledge to the contrary can only really occur when you already have sufficiently accurate information to determine the veracity of the certification. And so this was a question that we kind of got a fair amount, from plan sponsors was, what steps do I need to take to, if any, to verify a claim for a CRD? And really the answer is not too much beyond the submission of the self-certification form. Finally, when the CARES Act was initially released, we didn't have any sort of sample form to use, but a sample certification form was subsequently provided by the IRS in its subsequent guidance. So that was very helpful for TPAs and for plan sponsors. Finally, a CRD could be classified as pretty much any distribution from a qualified retirement plan to a qualified individual, so someone who is self-certified, that was made during 2020. And so this was kind of broadened with the IRS's subsequent guidance. The first takeaway here is for those of you who work with money purchase plans, so governmental plans, for example, there was initially a fair amount of confusion on whether a 401a money purchase plan could even offer a CRD outside of basically just another kind of distribution right. So it was unclear whether basically a money purchase plan could offer a CRD similar to, for example, a 401k plan could. The government actually came out in legislation and overturned the IRS's position on this, stating that money purchase plans could, in fact, offer CRDs. It was kind of ironic because this was actually done a little too late. This was done after 2020 had already closed. And so it really only benefited those money purchase plan sponsors who had essentially erroneously granted CRDs in 2020, but provides some relief for them. The CRD classification also applies if the plan itself did not treat the distribution as a CRD, or even if the amounts that were withdrawn were not withdrawn solely to meet a need arising from COVID. So just kind of a generally pretty liberal position taken by the IRS as far as what can qualify as a CRD. So, the CRD period's already closed now because we're well past 2020. At this point in time, we are kind of at a point where what's more relevant is basically the tax treatment and reporting of CRDs and recontributions. So under the CARES Act, if you took a CRD, you're actually allowed to recontribute that amount, and that's basically done via more or less a rollover process back into a qualified retirement plan or IRA, which doesn't necessarily have to be the plan which the CRD was taken out of to begin with. But if you recontribute this amount, you're allowed to basically go back and amend your tax returns in which you had included the amount as income to basically get a tax refund of those amounts. And so both the reporting of distributions and recontributions are accomplished on a new IRS form. That's IRS Form 8915E. That form can actually be used not only to report CRDs, but also qualifying disaster distributions, which we won't address in this presentation, but are another kind of new. In any event, I think I was talking about just from a plan sponsor perspective, you're not actually required to accept recontributions of coronavirus related distributions. For example, if as a plan you did not accept rollover contributions, you don't need to do so in order to permit these recontributions. And again, if these amounts are contributed within 3 years, they'll be treated as basically a non-taxable trustee to trustee transfer. One thing to note is the IRS in its recent guidance about this clarified that basically beneficiaries of death benefits other than spousal beneficiaries cannot actually repay a coronavirus related distribution. So that's something to keep in mind if you're a plan sponsor of a plan that permits recontribution. Okay, I'll briefly cover some of the loan relief that was offered under the CARES Act. Again, the actual suspension period has already passed. It was basically if somebody was a qualified individual, they were allowed to suspend their participant loan repayments for the period between March 27th, 2020 through the end of 2020. Repayments of those amounts would be delayed for a year. Again, like coronavirus related distributions, this was permissive relief on the part of plan sponsors. So as a plan sponsor, you did not need to necessarily offer this type of relief. However, if you did offer the relief, you will need to amend your plan to note that by the plan amendment period, which we will cover here soon in a slide. The IRS has issued basically safe harbor relief with respect to the loan relief that was offered in the CARES Act. And so under the safe harbor approach, the IRS basically says that repayments have to recommence with the first loan payment date in 2021. This was kind of an item of confusion for a lot of plan sponsors because the CARES Act itself states that loan repayments can be suspended for 1 year. But nonetheless, we typically advise plan sponsors to follow the safe harbor approach, even though alternative approaches may be available, you may wish to check with your TPA to see what they're willing and able to accommodate if you wish to take an alternative approach to loan repayment relief. And finally, just want to touch briefly on the RMD relief under the CARES Act. The CARES Act basically waived required minimum distributions for defined contribution plans and IRAs in 2020. This was issued after an amount of time had already passed in 2020, and so subsequent guidance basically said that taxpayers who had already taken 2020 RMDs, so before that the CARES Act was issued, were able to actually roll them back into their retirement accounts to take advantage of this relief. And also the relief applied to 2019 RMDs for someone who had turned 70 and a half in 2019, but hadn't taken their RMD yet before that April 1st, 2020 deadline. So that was pretty in line with RMD relief that they've granted in the past with respect to kind of economic downturns and disasters and so forth. Finally, the takeaway for plan sponsors from all of this is that if you did grant any of this relief that was permissive under the CARES Act, you have to make sure that you amend your plan by these deadlines. So for private sector plans, they have to be amended essentially by the last day of the 2022 plan year, and governmental plans. So for example, money purchase or 401A plans have a little more time. They have until 2024. And the practical takeaway here is if you did offer the relief, make sure you're documenting all of this so that you can properly draft whatever amendments are required. Okay, I wanted to briefly touch on the good faith relief that Kirsten had mentioned earlier in her presentation. So this was actually issued by the DOL. And so the DOL issued basically EBSA Disaster Relief Notice 2020-01, where they basically adopted a pretty liberal and pretty forgiving enforcement position with respect to delays in notices, required notices, and other kind of administrative acts as a result of the coronavirus pandemic during the outbreak period. And so the key takeaway here is that from the DOL's perspective, at least, an ERISA plan and the responsible plan fiduciary will not be in violation of ERISA for failure to timely furnish a notice, disclosure, or document that had to be furnished during that outbreak period, so long as that fiduciary acted in good faith to furnish that whatever was required as soon as possible under the circumstances. And good faith acts naturally include the use of alternative electronic means to communicate with plan participants and beneficiaries, which I'm sure plan participants were doing quite a bit during the pandemic. And so the specific items that the good faith relief applies to are things like verification requirements for plan loans or distributions. It also applies to, the special loan deferral administration that we talked about a few slides ago under the CARES Act. And it also applies to things like deposit timing, so deferral timing and loan repayments and blackout notices. And so a couple takeaways there beyond just what's provided in the notice. One thing to note is that this was issued by the DOL and not the IRS. So it concerns the DOL's enforcement position. It doesn't necessarily, imply that the IRS is going to go easier on you. It also doesn't affect any participant's individual right to enforcement of these notice requirements. And so it's still potentially possible that a participant could try to bring an action to enforce these requirements. This good faith relief only really applies to the DOL, cracking down on plan sponsors over these requirements. Okay, we're running out of time here, so I just want to touch briefly on the partial plan termination relief. This was relief that basically recognize that a lot of plan sponsors may have had to cut back on their plan populations due to the coronavirus pandemic. And so it basically provides a bright line to say, okay, if you have at least 80% of the number of participants, active participants in your plan as of this later date, March 31st, 2021, as you did, during the period from March 13th, 2020, then, we will consider that as not incurring a partial plan termination. That can be particularly helpful for plan sponsors who had to cut back on certain aspects or parts of their workforce as a result of the pandemic. Okay, last but not least, and I know we're running out of time, I just want to spend a couple of minutes just bringing to light the fact that the DOL very recently in April released 3 key pieces of cybersecurity guidance. They had been kind of hinting about this for a number of years, but they finally released these 3 pieces of guidance. And why this is important is that it appears to establish some minimum expectations, at least on the part of the DOL, of plan fiduciaries as far as establishing cybersecurity as an enforcement objective and something that they will be paying attention to going forward, and B, potentially imposing that as a part of integral part of a plan fiduciary's duties that are required under ERISA. And so we would advise that, plan sponsors pay attention and read the new guidance and incorporate that new guidance into, selection of any service providers, selection of TPAs, and also the ongoing review and basically evaluation of how those TPAs are doing as far as adhering to the guidance that the DOL has provided. I won't necessarily go into the specific items here. They're fairly self-explanatory because they are fairly in line with existing cybersecurity guidance that was already out there, for example, in the world of HIPAA and in the world of just cybersecurity practices generally. But the guidance was basically broken down into 3 categories. The first category was tips for plan sponsors when they're hiring a service provider, how to ensure that service provider is adhering to strong cybersecurity practices. The second piece of guidance is actually directed towards record keepers and service providers themselves to basically set out a list of best practices that those service providers should be following. This, again, is an enumerated list on a lot of kind of common sense stuff, but this is something that plan sponsors should also pay attention to when evaluating how their service providers are doing, whether they're kind of keeping in step with what the DOL is expecting of them. And finally, the DOL, the third and final piece of guidance that the DOL issued was basically some online security tips that were intended to be distributed to participants and beneficiaries. Again, pretty common sense guidance, but we would suggest as a plan sponsor, distributing some kind of communication to your plan participants and beneficiaries consisting of these items and documenting that you did so. Again, the DOL hasn't issued a ton of guidance on this yet, but the fact that they are issuing this guidance would suggest that it might foreshadow future enforcement initiatives. It would also indicate that they're paying more attention to this as a fiduciary issue. So as a plan fiduciary, we would recommend that you pay more attention to cybersecurity, the cybersecurity guidance, and making sure that plan service providers are compliant with the DOL's guidelines. I apologize for going over by a minute, and I also apologize for the technical difficulties. I don't know if we have time for questions at this point, but any questions that we don't have time for, I'm sure we can address by email. Kirsten, did you have any thoughts before we transition to the Q&A?
No, I think we're all set. I don't see any questions. And I think we're up at time. So if you have questions, feel free to send them to us. We'll respond as soon as we can.
Yep, and you have our email addresses. I believe they were on the first slide of the presentation. We're happy to respond to any questions by email, and we both very much appreciate your time this afternoon.
Thank you, everyone.
Thank you very much.